I stood on my back deck that Tuesday morning, coffee in hand, staring at the skeleton of what would soon become my worst nightmare. The construction crew had arrived at dawn, and they were already setting posts into the ground on the common area directly behind my house in Ridgewood Estates, just outside Boulder, Colorado. My property sat on the ridge overlooking the Flatirons, and I had paid a premium for this view back in 2019. More importantly, I had legal documentation that protected it. My name is Warren Patterson, and I had moved to this planned community specifically because of the unobstructed vista of the iconic rock formations that made Boulder famous. When I purchased the property, my real estate attorney had insisted on including a view easement in the deed, a legally binding document that prevented any construction on the common area behind my lot that would obstruct sight lines to the mountains. The HOA had acknowledged it at closing. The previous homeowner had negotiated it specifically because the common area stretched for nearly 2 acres behind the property line, and without protection, the HOA could theoretically build anything they wanted there. I watched the workers unload lumber from a flatbed truck, my stomach churning. This was not a small project. They were framing something substantial, and it was going directly in my view corridor. I pulled out my phone and dialed the HOA management office. Ridgewood Estates HOA, this is Patricia speaking, a cheerful voice answered. This is Warren Patterson at 4287 Vista Ridge Drive. There is construction happening on the common area behind my house. I need to know what is being built and who authorized it. Let me pull up the records, Mr. Patterson, I heard typing. Oh yes, the new community pavilion. The board approved it last month. It will be a wonderful addition for residents to host gatherings. My jaw tightened. A pavilion? How large? I believe it is 30 feet by 40 feet with a peaked roof. There will be picnic tables and a BBQ area. Very exciting. That was not submitted to me for approval, and it violates my view easement. Construction needs to stop immediately. There was a pause. I am not aware of any view easement, Mr. Patterson. The HOA owns the common areas and has the right to improve them as the board sees fit. I have legal documentation that says otherwise. I need to speak with the HOA president immediately. That would be Mrs. Brenda Morrison. She is available on Thursdays from 2 to 4. Would you like to schedule an appointment? No, I need her contact information now. This is urgent. Patricia's tone cooled. I am not authorized to give out personal information. You can attend the next board meeting on the 15th, or you can schedule an appointment. I ended the call, my frustration mounting. The 15th was 2 weeks away. By then, this pavilion would be half finished. I went inside and pulled out my file cabinet, extracting the thick folder labeled House Purchase Documents. I flipped through the paperwork until I found what I needed. The view easement, recorded with the county, clearly stating that no structure exceeding 6 feet in height could be erected within the designated area behind my property that would obstruct views of the Flatirons. The document had been signed by the HOA president at the time of my purchase and was legally binding on all future boards. I scanned the document and composed an email to the general HOA inbox, attaching the easement and demanding immediate cessation of construction. Then, I walked back outside. The framing crew had already set 8 posts in concrete. This was moving fast. I crossed my backyard and approached the site. A man in a hard hat was reviewing blueprints. "Excuse me, I am the homeowner right there," I said, pointing to my house. "I need you to stop work immediately. This construction violates a legal easement." He looked up, squinting in the morning sun. "You need to take that up with whoever hired us, buddy. We have a contract and permits. We are just doing our job." "Who hired you?" "Ridgewood Estates HOA. Lady named Brenda Morrison signed the contract. I am telling you right now, this is going to be demolished. You are wasting your time and materials. He shrugged. Not my problem. I get paid either way. I went back inside and called my real estate attorney, Margaret Sloan. Her paralegal said she was in court, but would return my call by end of day. I left an urgent message and spent the next hour researching Colorado easement law. Everything I read confirmed what I already knew. A recorded easement runs with the land and is enforceable against subsequent owners and entities, including HOAs. The HOA could not simply ignore it. By lunch, the frame had taken clear shape. They were building a structure with support posts reaching at least 15 feet, exactly in the center of my view. When I stood on my deck, the framing already blocked a portion of the southernmost flatiron. This was going to be a disaster. Margaret called at 3. Warren, I reviewed the easement you emailed. This is ironclad. The HOA cannot build anything that obstructs your view. Did you notify them? I tried. They claimed they were not aware of it and refused to stop construction. They are working right now. You need to send a formal cease and desist immediately. I will draft it and have it couriered to the HOA management office and directly to the HOA president. If they continue after receiving it, we can seek an emergency injunction. Do you have the current HOA president's address? I will get it. I called Patricia back, and after some argument, she agreed to provide Brenda Morrison's address as it was part of the HOA public records available to homeowners. She lived 4 streets over, a large colonial-style house with an immaculate lawn. By 5 o'clock, Margaret had arranged for a process server to deliver the cease and desist to both the HOA office and Brenda Morrison, personally. I watched the construction crew pack up for the day, leaving behind a skeletal structure that already made my stomach turn every time I looked out my window. The next morning they were back. I could not believe it. They had received the cease and desist the previous evening. Margaret had confirmed delivery, yet here they were, attaching cross beams and preparing to install the roof trusses. I called Margaret immediately. They are ignoring it. Then we go for the injunction. I will file the emergency motion this morning. Can you be available for a hearing? The judge might schedule it as early as tomorrow. I will be there. I went outside and took photographs and video of the construction, documenting the progress and how it increasingly blocked my view. Then I heard a car pull into my driveway. I walked around front to find a woman in her early 50s stepping out of a white Lexus SUV. She wore expensive athleisure wear and oversized sunglasses. Her blonde hair was cut in a severe bob. "Warren Patterson," she called out. "That is me. I am Brenda Morrison, HOA president. We need to talk about this ridiculous cease and desist." I crossed my arms. "There is nothing ridiculous about it. I have a legal view easement. Your construction violates it." She walked toward me, her heels clicking on my driveway. "I have been president of this HOA for 3 years, Mr. Patterson, and I have never heard of any view easement. You cannot just make up documents to stop community improvements." "I am not making anything up. It is recorded with Boulder County. You can verify it yourself." I had our property manager check the files. "There is nothing." "Then your files are incomplete. The easement exists, it is valid, and you are violating it. Stop construction, or this will get much more expensive for the HOA." Brenda removed her sunglasses, her blue eyes cold. "This pavilion has been in the planning stages for over a year. We held community meetings. We sent out surveys. 73% of residents supported it. We allocated $35,000 from reserves. We are not tearing it down because you want to be difficult." "I am not being difficult. I am protecting my property rights. If you had done your due diligence, you would have discovered the easement before breaking ground. Our attorney reviewed everything. This is legal. Then your attorney is incompetent. I will see you in court. I turned and walked back toward my house. You will lose, she called after me. And when you do, we will bill you for all the HOA's legal fees. That is in the CC and Articus. I stopped and looked back. Actually, when I win, the HOA will pay my legal fees. That is how easement violations work. Read a law book. Her face flushed red, and she stormed back to her SUV, spraying gravel as she reversed out of my driveway. The hearing was scheduled for Thursday morning at 9. Margaret and I arrived at the Boulder County Courthouse 30 minutes early. The HOA's attorney, a man named Richard Keller, showed up at 8:55 with Brenda Morrison in tow. They did not acknowledge us. Judge Patricia Hendricks called the case at 9:15. We filed into her courtroom, and Margaret presented our motion for a temporary restraining order and preliminary injunction to halt construction pending a full hearing on the easement violation. Your Honor, Margaret began, my client owns property at 4287 Vista Ridge Drive in Ridgewood Estates. When he purchased the property in 2019, his deed included a view easement, recorded with the county as document number 2019-087654, which prevents any structure exceeding 6 feet in height from being erected on the common area behind his property that would obstruct views of the Flatirons. The HOA is currently constructing a pavilion with a peak height of approximately 22 feet directly in the protected view corridor. We have provided photographic evidence showing the obstruction. The easement is clear, it is valid, and the HOA's construction violates it. We ask that the court immediately order cessation of construction and require removal of the structure. Judge Hendricks reviewed the documents. Mr. Keller, the HOA attorney stood. Your Honor, the HOA disputes the validity and applicability of this alleged easement. First, the HOA was not a party to the easement creation. It was a private agreement between the prior homeowner and the then current HOA board, which no longer has any members serving. Second, the current board conducted extensive due diligence before approving this pavilion, including legal review, and no easement was discovered. Third, the property in question is common area owned by the HOA, and the HOA has the right to improve its property as it sees fit for the benefit of all residents. One homeowner cannot veto community improvements. The easement is recorded, Margaret countered. It runs with the land. It does not matter who was on the board then or now. The HOA is bound by it. Judge Hendricks looked at Keller. Did you search the property records? We reviewed the HOA's files, Your Honor. That is not what I asked. Did you search the county records? Keller hesitated. We relied on our internal documentation. So that is a no. Judge Hendricks flipped through the easement document. This appears to be properly recorded and legally sufficient on its face. The description of the protected area is specific, the restriction is clear, and it was acknowledged by the HOA at the time. Mr. Keller, can you provide any legal basis for why this easement would not be binding on your client? We would need time to research and respond, Your Honor. How much time? 2 weeks. 2 weeks, I whispered to Margaret. She held up a hand. Judge Hendricks shook her head. Construction is ongoing. 2 weeks of work could make this problem significantly worse. Here is what we are going to do. Construction stops immediately as of today. The HOA will conduct a proper title search and provide a written response to the easement claim within 1 week. We will reconvene for a full hearing on the preliminary injunction next Thursday. If the HOA violates this order and continues construction, I will hold the responsible parties in contempt. Is that clear? Yes, Your Honor, Keller said, though his tone suggested he was not pleased. Mr. Patterson, you are to take no action regarding the existing structure. It stays as is until we resolve this. Understood? Yes, Your Honor, we were dismissed. Outside the courtroom, Brenda Morrison pointed at me. This is not over. You are destroying community morale over a view. Do you know how selfish that makes you? I am enforcing my legal rights. If you had checked the records before spending $35,000 of HOA money, we would not be here. You could have said something at the community meetings. I did not know about them. When were they? We sent notices. I never received any notice about a pavilion. She waved dismissively. We sent emails to all residents. I never got an email. That is not our problem. You are responsible for keeping your contact information current. Margaret stepped in. Mrs. Morrison, I suggest you stop talking and consult with your attorney. You are on thin ice here. Brenda shot her a venomous look before turning and walking away with Keller trailing behind her, already on his phone. Over the next week, my home became a prison of anxiety. Every morning I woke up wondering if the HOA would defy the judge's order and continue construction. They did not, but the partial structure loomed behind my house like a skeleton, a constant reminder of the battle ahead. I researched everything I could about view easements, HOA disputes, and Colorado property law. Margaret prepared our case, gathering survey maps, photographs showing the view obstruction, and case law supporting easement enforcement. On Monday, I received an email from the HOA, copying Keller. It was formal and hostile, stating that their title search had confirmed the existence of the recorded easement, but that they disputed its enforceability based on several arguments. The easement was overly broad. It had been improperly granted without full board approval. It constituted an unreasonable restriction on the HOA's use of common property, and enforcing it would create an undue hardship on the community. They demanded I withdraw my legal action and proposed a compromise. They would lower the pavilion's roof to 12 feet and move it 10 feet south. I forwarded it to Margaret. She called me within the hour. These arguments are weak. The easement is not overly broad, it is quite specific. The approval process is irrelevant as long as it was properly executed and recorded, which it was. Reasonableness is not a defense to an easement violation, and hardship is their own fault for failing to check the records. As for their compromise, moving it 10 feet south and lowering it to 12 feet still obstructs your view and still violates the easement. We decline. What do? We go to the hearing on Thursday and get a preliminary injunction ordering them to tear it down. Thursday arrived. The courtroom was more crowded this time. Several Ridgewood Estates residents had shown up, apparently organized by Brenda. They sat behind the HOA's table, whispering and shooting unfriendly looks my way. Judge Hendricks reviewed the HOA's response. Mr. Keller, I have read your arguments. I am not persuaded. The easement is valid and enforceable. Your client built in violation of it. The question now is remedy. What is your position? Your Honor, we ask that the court deny the injunction and allow the HOA to complete the pavilion with the modifications we proposed, lowering the roof to 12 feet and relocating it slightly. This would minimize the view impact while allowing the community to benefit from the amenity. Miss Sloan. Margaret stood. Your Honor, the easement does not allow for structures exceeding 6 feet in the protected area. 12 feet still violates it. Moving it 10 feet does not solve the problem. Our Sightline analysis shows continued obstruction. The remedy here is simple. Remove the structure and do not rebuild in the easement area. The HOA has 2 acres of common land. They can build their pavilion somewhere else. Judge Hendricks looked at the survey map. Mr. Keller, Why was this specific location chosen? It is centrally located and accessible to the most residents, Your Honor. Are there other locations on the common area that would not violate the easement? Keller glanced at Brenda. There are other areas, but they are less desirable from a planning perspective. Less desirable is not the same as impossible. The court finds that the plaintiff has demonstrated a likelihood of success on the merits. The easement is valid and binding. The HOA's construction violates it. The HOA has alternative locations for the pavilion that would not violate the easement. Accordingly, the preliminary injunction is granted. The HOA is ordered to remove the existing structure within 30 days and to refrain from any construction in the easement area that exceeds 6 feet in height. Costs and attorney fees for this motion are awarded to the plaintiff. We will schedule a full trial on the permanent injunction, but based on what I have seen, I expect the result will be the same. The courtroom erupted in murmurs. Brenda stood up, her face red. This is outrageous. One person does not get to dictate what the entire community can do. Judge Hendricks fixed her with a stern look. Mrs. Morrison, your HOA is bound by the easements on its property, just like any other property owner. If you do not like it, you can attempt to negotiate a release with Mr. Patterson, but you cannot ignore it. This hearing is adjourned. Outside, a group of residents surrounded me. A woman in her 60s, her face pinched with anger, stepped forward. You should be ashamed of yourself. That pavilion was for everyone, and you ruined it because of your selfish need to stare at rocks. I am enforcing my legal rights, I said. The HOA should have checked before they built. You could have compromised, a man said. You could have let them lower the roof. It still would have violated my easement. I paid for this view. It is part of my property value. You care more about your property value than your neighbors. The woman spat. Margaret put a hand on my arm. Let's go, Warren. You do not owe them explanations. We walked to the parking garage, but I felt the weight of their hostility. I had won in court, but I had made enemies in my community. Over the next week, things escalated. I started receiving angry emails from residents, some of them shockingly nasty. One called me a selfish prick who should move to the middle of nowhere if I wanted privacy. Another said I was ruining the neighborhood and should be kicked out of the HOA. Several suggested I was greedy and should accept a cash settlement to release the easement. The HOA board sent a formal letter stating they intended to appeal the judge's decision and that they would hold me personally responsible for damages to community cohesion. Then came the retaliation. On the 15th day after the injunction, I came home to find a violation notice on my door. The HOA claimed my lawn exceeded the maximum grass height of 3 inches and that I had weeds in my flower beds. I walked my property. My lawn was fine, recently mowed by my landscaping service. The weeds were ornamental grasses I had planted intentionally. I emailed the HOA office with photographs and documentation from my landscaper. They responded that I had 7 days to remedy the violations or face a $50 daily fine. 2 days later, another notice. My house number was not clearly visible from the street and violated community standards. My house number was a 6-inch brass plaque next to my front door, identical to dozens of other houses in the neighborhood. I took photos of neighboring houses with the exact same setup and sent them to the HOA. They responded that my situation was different because my house was set back farther from the street, which was nonsense. Then came the third notice. My trash cans were visible from the street. They were supposed to be screened. I checked my CC and Articus. There was no such requirement. I emailed them the relevant section. They responded that it was a recent amendment passed at a special meeting. I requested a copy of the amendment and the meeting minutes. They said they would provide them in due course. It was harassment, plain and simple. Margaret advised me to document everything but not to engage beyond factual responses. They are trying to bully you into dropping the easement case, she said. Do not give them ammunition. Meanwhile, the HOA had not demolished the pavilion structure. The 30-day deadline passed. I notified Margaret and she filed a motion for contempt. The hearing was set for 2 weeks out. During those 2 weeks, the harassment intensified. I received a notice that my exterior paint color was faded and in violation of community standards. My house had been painted 2 years ago and looked fine. I received a notice that my mailbox post was deteriorating. It was not. I received a notice that I had parked my car on the street overnight, which was prohibited. I had not. My car was in my garage. I provided my garage camera footage showing the car had not moved. They responded that their enforcement officer had documented the violation and issued a $100 fine. I refused to pay. They sent a second notice adding a $50 late fee and threatening to place a lien on my property. I was furious. This was not about violations. This was punishment for daring to challenge them. I started keeping a detailed log of every interaction, every notice, every email. Margaret said we could potentially file a counterclaim for harassment and abuse of power if it continued. The contempt hearing arrived. Judge Hendricks was not pleased. Mr. Keller, my order required demolition within 30 days. It has been 45 days. Where is the structure? Keller stood. Your Honor, the HOA filed a notice of appeal and believed that stayed the injunction pending appeal. Did you file a motion for stay pending appeal? No, Your Honor. Then the injunction was not stayed. Your client is in violation of a court order. Why should I not hold the HOA board in contempt? Your Honor, there was confusion about the legal requirements. It was not willful disobedience. Confusion. Judge Hendricks' voice rose slightly. My order was clear. Demolish the structure within 30 days. Where is the confusion? Brenda Morrison stood up from the gallery. Your Honor, may I speak? You may approach with your attorney. Brenda and Keller approached the bench. Margaret and I joined them. Your Honor, Brenda said, we have been trying to work with Mr. Patterson to reach a reasonable compromise. We offered him $20,000 to release the easement. We offered to relocate the pavilion. We offered to lower it further. He has refused every attempt at resolution. We felt it was prudent to pause demolition while we explored these options. Mrs. Morrison, you do not get to pause compliance with a court order because you are negotiating. If you wanted a stay, you should have filed for one. And from what I understand, Mr. Patterson is under no obligation to compromise. He has a valid easement. You violated it. He is entitled to enforcement. But the community needs this pavilion, Brenda said, her voice taking on a pleading tone. We have families who want a place to gather. We have children who need play areas. One man's view should not override the needs of 300 families. Then you should have checked the property records before you built. This is not Mr. Patterson's fault. This is your fault. You have had 45 days to comply with my order. I am giving you 7 more days. If that structure is not demolished within 7 days, I will fine the HOA $1,000 per day until compliance. Additionally, I am awarding Mr. Patterson his attorney fees for this contempt motion. Is that clear? Yes, Your Honor, Keller said quietly. We were dismissed. As we left the courtroom, Brenda grabbed my arm. This is not over. You have made an enemy of the entire community. We will make your life here miserable. I pulled my arm away. Are you threatening me? I am telling you the reality. No one wants you here anymore. You are a pariah. Margaret stepped between us. "Mrs. Morrison, you just threatened my client in front of witnesses. I suggest you walk away before you make this worse for yourself." Brenda stormed off, and I realized my hands were shaking. This had gone far beyond a legal dispute. This was personal. The structure was demolished 6 days later. I watched from my deck as a different crew dismantled the framing, loaded it onto trucks, and hauled it away. When they finished, the common area was empty again, and my view of the Flatirons was restored. I should have felt relief, but instead I felt dread. Brenda's threat echoed in my mind. The harassment did not stop. In fact, it got worse. The HOA sent me a bill for $12,000, claiming it was my share of the legal fees and demolition costs under the CC and Artiques provision that allowed the HOA to charge homeowners for costs incurred due to their actions. Margaret fired back a letter stating that I was not responsible for the HOA's decision to violate my easement, and that the judge had already awarded me attorney fees, not the other way around. The HOA responded by placing a lien on my property for the unpaid amount. I had no choice. We had to go back to court. Margaret filed a motion to invalidate the lien and to permanently enjoin the HOA from further harassment. We also added a claim for intentional infliction of emotional distress and abuse of process. While we waited for the hearing, life in Ridgewood Estates became unbearable. My neighbors stopped acknowledging me. One couple I had been friendly with crossed the street to avoid me. My invitations to community events stopped. Someone left a note on my windshield calling me a lawsuit-happy jerk. Another night, someone egged my house. I called the police, but they said without witnesses or cameras showing who did it, there was nothing they could do. The worst came on a Saturday morning. I woke to find that someone had spray-painted "selfish" across my garage door in red paint. I called the police again. An officer came, took a report, and said they would patrol the area, but I could tell he thought it was a waste of time. I spent the afternoon cleaning the paint off, but the word had etched into my mind. I started to question whether this was worth it. Maybe I should have compromised. Maybe I should have accepted the money and let them keep the pavilion. But then I would look at my view, the Flatirons rising majestically against the sky, and I would remember why I had bought this house. This was my home. I had done nothing wrong. The hearing on the lien and harassment claims was scheduled for mid-April. By then, I had accumulated a file 3 inches thick documenting the HOA's retaliatory actions. 27 violation notices, most of them baseless. 15 emails from residents ranging from hostile to threatening, the vandalism incidents, and the bogus lien. Margaret was confident. "This is a slam dunk, Warren. The HOA has gone way over the line. Not only will the judge invalidate the lien, but I think we have a strong case for damages. Emotional distress, loss of use and enjoyment of property, maybe even punitive damages for the egregious nature of their conduct." The night before the hearing, I got a call from an unknown number. I almost did not answer, but curiosity got the better of me. "Hello, Mr. Patterson. This is Richard Keller, the HOA's attorney. I am calling to see if we can settle this matter before tomorrow's hearing." "I am listening." "The HOA is prepared to drop the lien, cease all violation notices, and pay your attorney fees to date, which I understand are around $15,000. In exchange, you withdraw your harassment claims and we all move forward. What about my damages? We are not admitting liability. This would be a mutual resolution. So you want me to walk away from everything the HOA has put me through over the last 3 months, and all I get is what I am already entitled to? Mr. Patterson, if we go to court tomorrow, this will get ugly. There are a lot of angry residents." The HOA board may present testimony about your behavior, your unwillingness to cooperate, the damage you have caused to community relations. My behavior. I enforced my legal rights. Everything else has been the HOA's doing. That is your perspective. Others see it differently. Then I guess we will let the judge decide. I am not settling. I hung up. Margaret called me 10 minutes later. Keller had called her too, making the same offer. I told him to put it in writing and I would present it to you, she said. But honestly, Warren, it is a lowball. You are entitled to a lot more given what they have put you through. I know. I am not taking it. The hearing the next day was intense. Judge Hendricks reviewed the evidence I had submitted documenting the HOA's conduct. Keller argued that the HOA was simply enforcing its rules, and that I was being oversensitive. He presented testimony from Brenda Morrison and 2 other board members claiming that all the violations were legitimate, and that they had no knowledge of any vandalism or harassment. Margaret cross-examined Brenda. Mrs. Morrison, Mr. Patterson received 27 violation notices between February and April. How many violation notices did the HOA issue to other residents during the same period? Brenda hesitated. I do not have that number in front of me. Would it surprise you to learn that according to the HOA's own records, which we subpoenaed, the HOA issued a total of 31 violation notices to all residents during that period? Meaning Mr. Patterson, one homeowner out of 300, received nearly 90% of all violations. Some properties require more enforcement than others. Is that why you issued a violation for his trash cans being visible when there is no rule requiring them to be screened? There is a rule. Can you show me that rule in the CC and Articus? It was a recent amendment. We requested a copy of that amendment. You never provided it. Does it exist? Brenda's face flushed. I believe so. You believe so, Mrs. Morrison. Is it not true that you and the board targeted Mr. Patterson with baseless violations in retaliation for his enforcement of the view easement? No, absolutely not. Margaret pulled out a document. This is an email from you to the other board members dated March 3rd. You wrote, and I quote, "We need to make Patterson understand that there are consequences for destroying community projects. Start documenting every violation on his property, no matter how minor. If he wants to play hardball, we will too. Does that refresh your memory?" The courtroom went silent. Brenda's face went from red to white. That was taken out of context. What context makes that statement acceptable, Mrs. Morrison? Keller stood. Objection, Your Honor. Argumentative. Overruled. Mrs. Morrison, answer the question. Brenda stammered. I was frustrated. The pavilion demolition cost the HOA money and upset a lot of residents. I may have expressed myself poorly, but we did not target him. Margaret handed the email to the judge. Your Honor, this email directly contradicts Mrs. Morrison's testimony. It shows a clear intent to retaliate. Judge Hendricks read the email, her expression hardening. Mr. Keller, does your client have anything to say about this? Keller conferred with Brenda, whose eyes were now glassy with tears. She whispered something to him, and he shook his head. Your Honor, we maintain that the violations were legitimate, but we acknowledge that emotions were running high and that perhaps the frequency of enforcement was excessive. We are prepared to drop the lien and commit to treating Mr. Patterson fairly going forward. Judge Hendricks leaned back. Perhaps the frequency was excessive. Mr. Keller, your client engaged in a systematic campaign of harassment against Mr. Patterson because he exercised his legal rights. This is not a gray area. This is retaliation, plain and simple. The lien is invalidated. The HOA is permanently enjoined from issuing any violation notice to Mr. Patterson, unless it is accompanied by photographic evidence, and a citation to the specific rule being violated, with a copy sent to his attorney for review. Furthermore, I am awarding Mr. Patterson damages in the amount of $25,000 for emotional distress and loss of enjoyment of property. I am also awarding punitive damages in the amount of $50,000 to deter this kind of conduct in the future. The HOA will pay all of Mr. Patterson's attorney fees. Finally, I am ordering the HOA board to attend mediation training on proper governance and homeowner rights. Mrs. Morrison, if I see you in my courtroom again for anything resembling this behavior, I will consider sanctions against you personally. Do I make myself clear? Yes, Your Honor, Brenda said, her voice barely above a whisper. I felt a wave of relief wash over me. It was over. We had won, completely and decisively. As we left the courthouse, Margaret squeezed my shoulder. You did it, Warren. That was about as total a victory as you can get. Thank you. I could not have done this without you. You fought for what was right. That takes courage, especially when everyone turned against you. Over the next few weeks, things slowly returned to normal, or at least a new version of normal. The HOA sent a formal apology letter, clearly drafted by their attorney, and issued a payment for the damages and attorney fees. Brenda Morrison resigned as HOA president 2 weeks later. I heard through the neighborhood grapevine that the board had pressured her to step down to avoid further embarrassment. A new president was elected, a retired engineer named Tom Reinhardt, who seemed far more reasonable. He sent me a personal note saying he had reviewed the case and apologized for how I had been treated. He also mentioned that the board was exploring alternative locations for a community pavilion that would not infringe on any easements. Slowly, cautiously, some neighbors began to acknowledge me again. A couple who lived across the street stopped to chat one evening when I was checking my mail. They said they had not agreed with how the HOA handled things and were glad it was resolved. Another neighbor brought over cookies as a peace offering, admitting she had sent one of the angry emails and regretted it. Not everyone came around. There were still residents who glared at me or avoided eye contact. I had become a symbol of something in their minds. The difficult homeowner, the guy who sued the HOA, the one who put his own interests above the community. I understood their perspective even if I disagreed with it. From their vantage point, I had killed a project they were excited about. They did not see the legal nuances or my property rights. They just saw that they did not get their pavilion, but I had my view back, and I had my peace. Every morning I stood on my deck with my coffee, looking at the flatirons, and I felt grateful. This was why I had bought this house. This was what I had fought for. One Saturday afternoon in late May, there was a knock on my door. I opened it to find Tom Reinhardt, the new HOA president, standing there with a rolled-up document under his arm. "Warren, do you have a few minutes?" he asked. "Sure, come in." We sat in my living room, and he unrolled the document on my coffee table. It was a site plan of the common area. "I wanted to show you this," Tom said. "The board has approved a new location for the community pavilion. It will be here, on the north end of the common area, about 200 yards from your property. We had a surveyor confirm that it will not impact your view easement at all. We are going to break ground next month." I studied the plan. The location made sense. It was still central and accessible, but completely outside the protected corridor. "This looks good," I said. "I appreciate you sharing it with me." "I also wanted to say something," Tom continued. "What Brenda and the board did to you was wrong. I have been on HOA boards before, and I have seen how things can go off the rails when egos get involved. You had every right to enforce your easement. The fact that you were harassed for it is shameful. On behalf of the current board, I apologize." We are committed to running this HOA properly and respecting homeowners' rights. Thank you. That means a lot. There is one more thing. He pulled out an envelope. The board voted to offer you a seat on the HOA board. We think you could bring a valuable perspective, especially on legal compliance and property rights. No pressure, but we would like you to consider it. I was surprised. That is very generous, but I am not sure I would be welcomed. A lot of residents still resent me. Some do, Tom admitted. But others recognize that you were treated unfairly. And having someone on the board who understands property law could help us avoid situations like this in the future. Think about it. After he left, I sat on my deck and thought about his offer. Part of me wanted nothing to do with the HOA ever again. The last few months had been exhausting and painful. But another part of me saw an opportunity. If I joined the board, I could help ensure that other homeowners were treated fairly, that the HOA followed the law, and that emotional decisions did not override legal obligations. Maybe I could turn this experience into something positive. I called Tom that evening and accepted the position. My first board meeting was in June. Walking into that room was intimidating. 2 of the board members had been there during the pavilion fiasco, though they had not been as involved as Brenda. They were polite but reserved. The other 2 members were newer and seemed genuinely welcoming. Tom ran the meeting efficiently. We discussed routine matters, budget updates, landscaping contracts, pool maintenance for the summer. Then we got to new business. I want to propose a new policy, I said. Before the HOA undertakes any construction or major project on common property, we conduct a thorough title search to identify any easements, restrictions, or encumbrances. We also notify homeowners whose properties are adjacent to the proposed project and give them an opportunity to raise concerns. This should all happen before any money is spent or contracts are signed. One of the veteran board members, a woman named Susan Teller, nodded. That makes sense. It would have prevented the pavilion issue. It will add time and cost to projects, the other veteran member, Greg Hollies, said. It will add some cost up front, I agreed. But it will save us a lot more in the long run if it prevents legal disputes, and it will build trust with homeowners. The board discussed it for 20 minutes and then voted unanimously to adopt the policy. It was a small victory, but it felt significant. We were learning from what had happened. Over the next several months, I settled into my role on the board. It was not always easy. There were still moments when I felt the tension from residents who remembered the lawsuit. But slowly, by being fair, transparent, and focused on what was best for the community, I started to earn respect. The new pavilion was completed in August. The HOA held a ribbon-cutting ceremony, and to my surprise, Tom invited me to participate. I hesitated, but he insisted. You are part of this community, Warren. You helped us get this right. I stood with the other board members as Tom cut the ribbon, and there was applause from the gathered residents. A few people even came up to me afterward to thank me for my service on the board. It felt like a turning point. That evening, I hosted a small barbecue on my deck. I had invited a few neighbors I had gotten to know better over the summer, including the couple who had apologized and Tom and his wife. We grilled burgers, drank beer, and watched the sun set over the Flatirons. The sky turned brilliant shades of orange and pink, and the rock formations glowed in the fading light. This is an incredible view, Tom said. I can see why you fought for it. It is more than just the view, I said. It is about principle. If people can ignore legal agreements whenever they find them inconvenient, then nothing means anything. Property rights matter. Contracts matter. You are right, Tom said. And I think a lot of people in this community have come to understand that, even if it took a while. As the evening wound down and my guests left, I stayed outside, sitting in the quiet darkness. The flatirons were silhouettes now against the starry sky. I thought about everything that had happened, the shock of seeing construction blocking my view, the legal battles, the harassment, the eventual vindication. It had been one of the hardest experiences of my life, but I had come through it stronger. I had learned that standing up for what is right often comes at a cost. People will not always understand or support you. You might become unpopular. You might face retaliation. But if you have the law on your side and the courage to see it through, justice will prevail. I also learned that communities are complicated. The people who had opposed me were not villains. They were neighbors who wanted something good for the community and were frustrated when one person seemed to stand in the way. Brenda Morrison had taken things way too far, but her initial motivation, creating a gathering place, was not malicious. The problem was that she let her emotions and her ego override her legal obligations. That was a cautionary tale for anyone in a leadership position. Serving on the HOA board gave me a new perspective too. I saw how hard it was to balance competing interests, to manage limited resources, to deal with hundreds of homeowners who all had different opinions and priorities. I developed empathy for the people trying to govern the community, even as I remained committed to holding them accountable to the law. One afternoon in October, I was working in my yard when a car pulled up. A woman in her 30s got out, looking around with interest. She walked up to me. "Excuse me, are you Warren Patterson?" "I am. My name is Emily Frost. My husband and I are looking at houses in Ridgewood Estates. Our realtor mentioned that you had a legal issue with the HOA over a view easement. I wanted to ask you about it because the house we are considering has a similar easement." I wiped my hands on my jeans and invited her to sit on my front porch. I told her the whole story: the pavilion construction, the legal battle, the harassment, the eventual resolution. "Wow," she said when I finished. "That sounds awful. Are you glad you fought it?" "Absolutely. If I had let them violate my easement, it would have been worthless, and they would have learned that they could ignore property rights whenever they wanted. Our realtor said some people in the community still resent you for it. Some do, but most have moved on, and honestly, I do not regret it even knowing how hard it was. This is my home. I have a right to protect it." She nodded thoughtfully. "That is good to know. We want to make sure our easement would be enforceable if we ever needed it. It is, as long as it is properly recorded. Just make sure you verify it with a real estate attorney before you close. And if you do buy here, feel free to reach out if you ever have questions about the HOA." She thanked me and left. As I watched her drive away, I felt a sense of satisfaction. Maybe my experience would help other homeowners protect their rights. Maybe something good would come from everything I had been through. The holidays came and went. In December, the HOA held its annual winter party at the new pavilion. I attended, and while there were still a few cold shoulders, most people were friendly. The pavilion looked great, and it was clear the community was enjoying it. I was genuinely happy that they had a space to gather, and I was glad it had been built in a way that did not infringe on anyone's rights. As the new year began, I reflected on the past year. It had been tumultuous, exhausting, and at times deeply painful. But I had defended my property, held the HOA accountable, and helped create better policies that would protect other homeowners in the future. I had turned a nightmare into an opportunity for positive change. One February morning, almost exactly a year after the construction had begun, I stood on my deck with my coffee. The flatirons were dusted with fresh snow, glowing in the early light. My view was unobstructed, pristine, perfect. I had fought for this and I had won. My phone buzzed. It was a text from Tom. "Board meeting tonight. Can you make it?" I replied. "I will be there." I finished my coffee and went inside to get ready for work. Life in Ridgewood Estates had returned to normal, or as normal as it could be after everything that had happened. I had made my stand, endured the backlash, and come out the other side. I had learned that doing the right thing is not always easy or popular, but it is always worth it. And every morning when I looked at the flatirons rising majestically beyond my property, I was reminded of why I had fought so hard. This was my home. This was my view. And no one, not even an HOA with 300 families behind it, had the right to take it away from me. The view easement I owned was not just a piece of paper. It was a legally binding protection of my property rights, and when push came to shove, the law had sided with me. The experience had taught me resilience, patience, and the importance of standing firm in the face of opposition. It had also taught me humility and the value of community, even with people who had opposed me. We were all neighbors, all trying to build good lives in this beautiful place, and while we would not always agree, we could find ways to coexist and respect each other's rights. As I drove to work that morning, I thought about the path ahead. I would continue serving on the HOA board, working to make Ridgewood Estates a place where rules were followed, rights were respected, and conflicts were resolved fairly. I would continue to be a voice for accountability and legal compliance. And I would continue to enjoy my home and my view, knowing that I had fought for them and won. The legal battle over the pavilion had been intense and costly, both financially and emotionally. But it had also been necessary. It had set a precedent that the HOA could not simply bulldoze over property rights, even for well-intentioned community projects. It had shown that individual homeowners could stand up to powerful community organizations and prevail when they had the law on their side. And it had reminded everyone in Ridgewood Estates that living in a planned community did not mean surrendering your fundamental property rights. Looking back, I would not change anything. Yes, it had been hard. Yes, I had lost friendships and faced hostility. Yes, there had been moments when I questioned whether it was worth it. But in the end, justice had prevailed. My easement had been enforced, the illegal structure had been demolished, and the HOA had been held accountable for its retaliatory conduct. The damages and attorney fee awards had sent a clear message that harassment and abuse of power would not be tolerated. More importantly, the experience had changed the culture of the HOA. Under new leadership, with better policies in place, Ridgewood Estates was now a community that took property rights seriously. Future homeowners would benefit from the precedent that had been set. Future boards would think twice before ignoring easements or retaliating against homeowners who asserted their rights. As I pulled into my office parking lot, I felt a deep sense of peace. The battle was over, and I had emerged victorious. My view was protected, my rights were vindicated, and my community was stronger for having gone through this difficult process. Sometimes the hardest fights are the ones most worth fighting, and this had been one of those fights. I had learned that courage is not the absence of fear, but the willingness to do what is right despite the fear. I had learned that persistence pays off, that the legal system, while slow, generally works when you have a strong case. And I had learned that home is worth fighting for, not just the physical structure but everything it represents. Security, peace, beauty, and the right to enjoy your property without interference. The flatirons would be there tomorrow morning and the morning after that and for years to come, framed perfectly in my view, a daily reminder of what I had fought for and won. And that made everything worthwhile.